Thank you, Madam Speaker. This immigration amendment bill addresses defects in our immigration law that were declared unconstitutional in the 2017 Lawyers for Human Rights versus Minister of Home Affairs and others case. The bill intends to amend the constitutional defects of Section 34(1) of the Immigration Act of 2002, which prescribes the procedures for detention of an illegal foreigner before deportation. The bill aligns our immigration system with the Constitution, while giving the state stronger tools to enforce the law against illegal immigration. One of the most important aspects of this bill is the introduction of a clear interests of justice standard when dealing with the arrest and detention of illegal foreigners. Previously, too much discretion was left in the hands of immigration officers and magistrates. Decisions to detain or release were inconsistent, vulnerable to abuse, and often not subject to adequate oversight. That created two dangers. First, the risk of arbitrary detention, which the courts could not tolerate, and second, the risk of arbitrary release, which undermined the immigration enforcement and public confidence. This bill corrects that by requiring that the Minister of Home Affairs to set out regulations prescribing the factors that must be considered. Immigration officers and magistrates will no longer be guided by standard operating procedures that were not visible to magistrates nor detainees. They must apply the law against a set of clear and publicly available standards. Importantly, these interests of justice criteria do not weaken our hand against illegal immigration. In fact, the opposite, they strengthen it, because they ensure that every detention and every deportation stands up in court. It is costing South Africa 427 Rand per day to detain an illegal foreigner, and so it is important to prevent endless appeals and litigation that only delays deportations. The bill also restores proper judicial oversight. An illegal foreigner arrested for deportation must be informed of their rights in a language they understand where possible, brought before a court within 48 hours, detained only if a magistrate authorizes it, initially for 30 days and subject to further detention only if the court extends it for up to 90 days at a time. At each stage, the illegal foreigner has the right to make oral or written representations. This ensures that courts, not unchecked officials, make the final decision. By embedding these safeguards, we ensure that enforcement cannot be overturned on technicalities. We protect the integrity of the deportation process, making sure it is quick, lawful, and sustainable. Madam Speaker, let me turn to a group that deserves special mention, and that is children. Migration often hides a child's face. Children may arrive with families, or they may arrive alone. They may be victims of trafficking, or simply caught up in adult circumstances beyond their control. Our Constitution is unequivocal. In every matter concerning a child, the child's best interests are of paramount importance. The bill affirms that principle. It ensures that children are not simply processed as illegal foreigners, but dealt with under our child protection frameworks, particularly the Children's Act. What does this mean in practice? It means a child cannot be detained for immigration purposes except as a last resort, and only under judicial supervision. It means children must be referred to the appropriate child protection authorities, not locked up in facilities designed for adults. It means the Department of Home Affairs must cooperate with social services, the police, and the courts to ensure that children's safety and welfare comes first. We welcome the assurance from the State Law Advisor and the Department that these protections are already being embedded in law and in practice. But vigilance is key. We cannot allow the rights of children to be lost in the shadows of immigration enforcement. And we also reiterate our call for the Portfolio Committee on Home Affairs to engage with the Department of Social Services on how they process the children of illegal foreigners, but also how they assist South African children in accessing their rightful documentation so that we defeat statelessness and ensure that each and every South African child enjoys the dignity of an identity and access to opportunity. House Chair, for far too long, undocumented foreigners have been able to enter and exit South Africa at will. And this bill is another step towards stronger implementation of the rule of law. This means being firm in enforcing the law unapologetically and firm in upholding the Constitution. Illegal immigration is not a minor inconvenience. It threatens our sovereignty, places heavy pressure on public services, undercuts employment for South Africans, and creates fertile ground for criminal syndicates. This is why the Department of Home Affairs, together with the Border Management Authority, has intensified enforcement efforts under the leadership of Minister Leon Schreiber. The progress in just over a year has been remarkable. In 24-25, 51,000 illegal immigrants were deported. That is an 18% increase on the previous year, the highest figure in at least 5 years, and that number is greater than the combined deportations of France and Germany in the same period. Immigration enforcement operations have surged from 383 to 1,415 in Q4 of 24-25. This nearly four-fold increase included extensive interventions to uphold the rule of law, dealing with zama-zamas and foodborne diseases in spaza shops. This increase in internal enforcement follows a 215% increase in the successful prevention of illegal border crossings in the 24-25 festive season, and a 63% increase in the successful prevention of illegal border crossings over the Easter period. The Border Management Authority continues to punch above its weight, thanks to the introduction of drones, artificial intelligence, and smart surveillance as part of Minister Schreiber's system modernization program. Operation New Broom, launched earlier this year, uses biometric technology to identify and prosecute illegal foreigners. Already in Pretoria's Plastic View settlement, 95 illegal immigrants were arrested. Similar operations are expanding. Now, these results show that enforcement is working, but without the constitutional fixes in this bill, many of these deportations could be challenged in court and overturned. And so by passing this bill, we are locking in those successes on a foundation of legality. Madam Speaker, the people of South Africa are rightly demanding action. They want to see their government take control of immigration, protect our borders, and uphold the law. This bill does exactly that. It ensures that immigration enforcement is constitutional. It protects the rights of children. It equips our officers and courts with the tools they need to deport illegal foreigners swiftly and lawfully. The Democratic Alliance supports this bill because in South Africa we believe that the rule of law is non-negotiable, that children must be protected and that illegal immigration must be confronted head-on so that we are not denied the benefits of lawful tourism into South Africa that will help grow the economy and create jobs. Thank you, Madam Speaker.